What's problematic with this is the fact that you have already agreed that in terms of the sections, he ought not to have been joined at all. He ought not to have been. Now, what makes this situation worse is the fact that he is being joined down the line. Not that it would have been correct if he had been joined at the same time the charges were brought. No, that would still have been legally wrong in terms of 155 and 156, and you've agreed to that. Now, but what makes it worse here, he is joined down the line. Surely, your minds should have focused on, we already have charges against all of these people. We are charging them with fraud and corruption. Now we want to put in an additional person. Is it in accordance with the law to join him in terms of 155 and 156? Surely your mind should have been focused on that. It's not as if a mistake happened, we just lumped these people together instantaneously, it sort of just happened. But anyway, I say, things like these cannot just happen. So if it's wrong in law, it would have been wrong, even if it was lumped right at the beginning. But now, the point I'm making is, you lump those together, they are all charged with fraud and corruption. It makes sense to lump them together in terms of 155 and 156. Now with him down the line, how is it that your minds are not specifically or particularly focused on, but must we lump him together with them? Surely your minds should have been so focused. Otherwise, I do not understand why that was not the case.
I understand you, Chair.
Did you? I may be repeating Commissioner Baloyi's question, but I will repeat it for emphasis. Did you focus your own mind on this issue at all?
Yes, there was a discussion on whether he was going to be charged separately or whether he was going to be joined. I give the argument and can take it no further than what was given.
After that discussion, or during that discussion, did you specifically focus on which basis under 155 or 156 we can join him? Did you focus your minds on that?
Not me specifically.
When you said there was a discussion, did that discussion not involve you?
The discussion involved with 157. Should he be charged separately or should he be charged jointly? The prosecution
you
team...
can't, sorry. You can't separate 157. It must relate to 155 and 156 as well. You cannot separate 155 because you charge people in the same proceedings if they have committed the same offense.
That discussion happens and then we go to we then go to Commissioner Masemola.
So you were part of that discussion, you say?
With the prosecutors. Yes, when they did the briefing.
Yes.
Yes, there was an engagement with the prosecutors.
Yes. And you concluded that there was a legal basis in terms of the Criminal Procedure Act to join him in these proceedings. And if you say so, and you must have reached that decision. So if you say you found a legal basis, what was that legal basis? And in terms of which section exactly?
So in terms of the legal basis that we found, Chair, it was the argument was used as the at the bottom of 156 of them being charged together because the evidence at the trial of the one would be used and may be admissible at the trial of the other person.
Is evidence about the commission of corruption, the commission of fraud admissible as against General Masemola? If so, for what purpose?
Not admissible against him, but to lead that evidence to
No,
then
Joy, but-
show it.
Continue. Please continue.
Okay. It was in having this one trial, you lead the evidence of the fraud, the corruption, all of those irregularities. And it's all the same evidence that will then talk to the PFMA evidence, because you would have to lead, if you take him and put him separately, you would still have to lead that same evidence to get to him, to show what was it, what was the irregularities and or the unlawfulness that was happening, who all was involved, and what were his duties. So instead of duplicating that evidence, they put them all in one matter. We would lead that evidence. It will then in turn show that that serious complex corruption, etc., that happened, had it been stopped when it should have been stopped, would not have led to this. Not doing it together, Chair, as was argued, would mean we'd have to do two separate matters. That was the discussion at the time.
Was that correct, insofar as he's concerned? Remember, you just said, in response to my last question, you just said, evidence of the commission of corruption and the commission of fraud is not admissible as against General Masemola. And if you look at 156, that is what a prosecutor must tell the court as to why the prosecutor is joining the accused persons together. So if you accept, as you did in response to my last question, that evidence of fraud and corruption is not admissible as against General Masemola, you do not get off the starting blocks under 156. Do you agree?
I agree.
So he
I was
was
giving you the discussions that we had.
which were wrong ultimately in terms of the decision that was reached. Do you accept?
I'll accept it.
Thank you.
Thank you, Chair and Commissioners. Let's stay with the Major General Matlo's referral affidavit. And that's file 9, page 3519.